And good morning to everybody. Over the past 3 years, the administration has undertaken an unprecedented effort to transform our nation's immigration enforcement system into one that focuses on public safety, on border security, and on the integrity of the immigration system. As part of our approach, we have appropriately shifted our enforcement focus on individuals who pose a danger to national security or represent a risk to public safety. And specifically, this has meant removing those with criminal convictions in addition to immigration violations, those who are recent border crossers, and those who are repeat violators. And in fact, just about 90% of our removals last year fell within these priority categories. Last year, we also empowered our ICE, Immigration and Customs Enforcement, attorneys, officers, and agents to use the discretion they have in deciding whether to close removal cases where appropriate and responsible to do so. This action helped us ensure that incoming immigration cases and existing caseloads more closely correspond with our priorities and ensure that low-priority cases don't clog the immigration courts or take up our resources. However, I believe that additional measures are needed to ensure that our enforcement resources are not expended on low-priority cases, but are instead appropriately focused on people who meet our enforcement priorities. Therefore, consistent with our existing use of prosecutorial discretion, today I am announcing that effective immediately, young people who were brought to the United States through no fault of their own as children and who meet several key criteria will no longer be removed from the country or entered into removal proceedings. Those who demonstrate they meet the criteria will be eligible to receive deferred action for a period of 2 years, and that period is subject to renewal. Now, in order to be eligible for deferred action, individuals must have come to the United States before the age of 16. They must have continuously resided in the United States for at least 5 years preceding today's date, and they must be present in the United States as of today. They must be currently in school, have graduated from high school, have attained a GED, or be an honorably discharged veteran of the Coast Guard or Armed Forces of the United States. They also need to show that they've not been convicted of a felony offense, a significant misdemeanor offense, or multiple minor misdemeanor offenses, and that they do not pose a threat to national security or public safety. And finally, they must be younger than the age of 30. Individuals must also complete a background check, and for the process to be developed by CIS, must be 15 years or older, unless subject to a final order of removal. Only those individuals who can prove through verifiable documentation that they meet the criteria will be eligible for deferred action. Individuals will not be eligible if they're not currently in the U.S. or cannot prove that they have continuously resided within the United States for 5 years. The granting of deferred action under this new directive will not provide an individual with permanent lawful status, and it will not provide a pathway to obtaining permanent lawful status or citizenship. This grant of a deferred action is not immunity. It is not amnesty. It is an exercise of discretion so that these young people are not in the removal system. It will help us continue to streamline immigration enforcement and ensure that resources are not spent pursuing the removal of low-priority cases involving productive young people. More important, I believe this action is the right thing to do. Our nation's immigration laws must be enforced in a strong and sensible manner, but they are not designed to be blindly enforced without consideration given to the individual circumstances of each case. Nor are they designed to remove productive young people to countries where they may never have lived or even speak the language. Indeed, many of the young people who will be eligible for deferred action already have contributed to our country in significant ways. These young people do not represent a risk to public safety or security. Yet as long as there are no legal options available for them to adjust their immigration status, they will continue to be part of the population subject to immigration enforcement under the law. So prosecutorial discretion, which is used in so many other areas, is especially justified here. This policy represents the next logical step in our efforts to transform the immigration enforcement system into one that focuses on public safety, border security, and the integrity of the immigration system. It not only reflects sound law enforcement policy, it will result in a more efficient and productive immigration enforcement system. I continue to urge Congress to pass the DREAM Act and to re-examine our immigration system as a whole. The decision I announced today, however, is well within the framework of our existing laws. We should not forget that we are a nation of laws and a nation of immigrants. And as I said earlier, with